You have questions, we have answers. This is Jane Muller.
And this is Ken Muller. Welcome to our show, all about real estate with Ken and Jane. So a couple weeks ago, we had a show on landlord-tenant issues that commonly arise in residential leases. We kind of left off, we kind of brushed over the last topic of security deposits. So I want to pick it up there and delve a little bit more into the security deposit law in New Jersey, and then talk about a few other important items that are on the New Jersey Truth in Renting booklet that is needed to be read by both landlords and tenants in their entirety before signing a lease. So we should preface the show by stating, as we did the last time we spoke about landlord-tenant, that this is only a discussion based on our knowledge and experience of reviewing and dealing with a lot of landlord-tenant issues. It's for information. If you have any particular legal issues, you have to consult with an attorney, the landlord-tenant attorney. He or she is the only person that can give you legal advice.
Yes. This is not the legal advice. It's just we share something we know.
Right. Yeah. So security deposits are, again, to recap a little bit, the maximum for a residential lease that a landlord can ask for is 1.5 months of a security deposit that has to be put into a landlord-tenant interest-bearing account. You're holding that as a custodian for the tenant, and it's only to be used in the event that there's actual damage or unpaid rent at the end of the lease term.
Once again, that's the end of lease term.
Yeah, the end of the lease term.
You cannot just use it during the lease. I have a lot of questions. People ask me, said, can I get access to that funding? We would say, once again, you can get legal advice. But if you ask me, answer is no. Yeah,
so there's so many regulations. And again, our purpose is not to give you legal advice, but just to advise you that if you're a landlord, you have to open up this landlord-tenant account. You have to let the tenant know where the account is, the location, the bank account number, the interest-bearing amount. And
because this is not your money. This is in trust account.
It's a trust account, exactly. Yeah. And again, it's only to be used if there is, in fact, damages at the end of the lease term. And then you have to make sure, if you're both the landlord and the tenant, that you have a clear understanding of what's damages versus what's normal wear and tear.
You have to have agreement.
You have to have a normal wear. Well, normal wear and tear could be things like a faded carpet, discolored walls, painting on the walls, scuff marks. Those things are commonly, whereas as opposed to damages, which could be a broken appliance due to the willful abuse or neglect of the tenant. Things like broken holes, big holes in the wall. Things Ken, you have to. It's fact specific. So
yeah, this is a very very gray area, because I there was like a long time ago. I remember my sister-in-law, right, when they called me up and said, Jane, my landlord is not fair to us. And they want to keep us a deposit because they have to repay the condo. But we lived there for a long time. And I said, I would agree with landlord. He said, why? I said, did you see your kids, my niece and nephew, they draw on the wall everywhere. And sometimes the kids even jump off the bed to see who can, make marks on the ceiling. It's crazy.
Right. So that's
and she said, no, that's wear and tear.
No. The question she's right, but it's not normal wear and tear. Yeah. That's the question. Normal meaning
for
that
for her is normal.
The kids normally. Well, I guess you could argue that too. Normally, the kids don't write. Don't put crayons and write on
they
the
are kids.
on the
That's
wall.
Her thing. But I said.
Right.
I mean, I'm a mother. I have my kid. My kid never did that.
So the normal thing, I guess it's like everything is fact specific, but you could say after being a tenant long term at a particular place of 8 to 10 years, normally walls will fade and need to be painted. That's a cost that the landlord should normally have to absorb. However, if there's blatant writing and markings and tenant, magic markers on the walls, and that could be arguable.
But I think, Ken, I could be wrong here, right? I remember a long time ago, there was a case. Well, we're not involved. There wasn't. I didn't represent either party. I remember a long time there was a case. Remember, somebody called me and ask you that time, your attorney ask you whether they should wear a suit to the court. I said, just somebody I know in the community. I said, well, why? Why you go to court? He said the landlord took him to court because his kids write crayons on the wall, and the landlord want to charge him. Actually, he didn't want to court himself, and he won the case. But that was a long, long time ago. There was no
and every case is fact specific, and it really depends.
That was no punishment to the landlord. But later on, the law changed. If the court agreed with the tenant side, there's a penalty to the landlord.
Right. The penalty is like, let's say hypothetically, the landlord arbitrarily withheld $500 from the security deposit because they had to repaint a few walls because there's crayon markings. If based on the facts, the court determined that the withholding was wrongfully withheld, then the landlord could be punished, be liable for punitive damages according to what the statutes state in the amount of 2 times the wrongful amount. So if you wrongfully withheld $500, the landlord could be assessed a $1,000 penalty in this particular example. So it's all fact specific. You don't know how much the extent of the markings were. Maybe it was just a few crayon spots and it was normal wear and tear, as opposed to crayon markers every single wall of every room.
Ken, it really depends on the judge, right?
And it depends.
If the judge believes the tenant lived there 5 years, for example, you do to repaint the whole house. So
you do anyway, right?
Also, the town is different because certain town does have a requirement you have to freshly paint after a certain time.
Yeah, North Brunswick. We were just talking about this with somebody in our in the office. North Brunswick, they have every time they have a rental inspection before.
Yes.
Besides the landlord and the tenant having their own checklist, the township of certain towns like North Brunswick will come in and they'll do an inspection to make sure that the cleanliness, make sure the caulking is proper, make sure the refrigerator, all the appliances are clean, make sure all the windows are operable, make sure there's no holes or cracks in the windows. The carpeting is in good condition. So they do a functionality and an overall cleanliness inspection.
Yes.
So they want to make sure that the
every
place
town is different.
Is livable, yeah. Mm-hmm. So, but I think this gets to the next topic I want to talk about. How the best thing in life is always if the landlord and the tenant can agree and come to a clear understanding. And how do you do that? You do that by before moving in. What's critical is that the tenant have a pre-move-in walkthrough with the landlord or with the landlord's designated agent, so that way you can go through the unit, whether it be the apartment or the house, and go through it and document in writing anything that's visibly noticeable, that just so the tenant, even if you don't want the landlord to fix it, just so that you as a tenant are not blamed for it.
Yep.
And you can supplement that with video, camera, video or pictures are good, and then you come to a clear understanding that so you know the condition of the unit before you occupy it, and then when you move out, you do a walk. You have that documentation to fall back on.
Yep.
So you might document, like for example, if there's a hole in the rug. Not that you necessarily want the landlord to replace the carpet. You just want to say, in the master bedroom, there's a hole in the corner of the rug, so you're not blamed for it.
Yes. I think that's to protect both parties, both landlord and tenant, so they have a clear understanding. Memory can fade, right?
Of course.
So always in writing. So we do that for every listings. We have walk-in, the final walkthrough and walk-in. We have walk out.
Move out, walk through, right.
Walk through. So that we always make sure to let landlord know, and with the written
and besides,
report,
you want to but the walkthrough. You should obviously do the visual inspection of all the rooms. You want to test the stove, all the burners, test out, and then certain things that aren't tested at the time of the walkthrough. For example, if you don't test the washing machine or the dryer, you want to at least do that shortly thereafter, so that if there is a problem, you can notify the landlord in a timely manner and say, hey, I noticed this within normally, I think they give the tenant 2 weeks to iron out.
You don't tell them 6 months later it's broke.
Yeah, and they're going to say, well, that's on you because
that's right.
It's due to your responsibility. Yeah. So that's really important, and that'll help. That'll smooth a lot of matters before they become legal. You want open communication with the landlord, and I think usually if parties communicate, a lot of times you can put your heads together. It's better you do it openly, resolve it than to have the courts do it, because it's just a lot easier and it's a lot.
A few days ago I had a case, right? The landlord tenant have issues, and I said to the landlord, I think we should fix it. But the landlord say, no, we shouldn't. I don't need to fix it. So they insist to seek legal. I mean, I said to them, you can seek legal advice, right?
Mm-hmm.
And after she Googled, find a few attorney, contact them. And one attorney respond to her is like, you can either pay me or you can fix it.
Right, because
but after you pay me, you still have to fix it.
right.
So
and
that
the cost
was like
to fix it was most likely less than the lawyer fee. And
yeah,
if you're going to have to fix it
the lawyer
anyway,
said you can pay me
and pay to
and
fix
then
it.
fix it, or you can just fix it.
Well,
So-
at least bravo to that lawyer for being honest and telling
That's right.
your client the realistic outcome
Yes.
of needing to fix it, and regardless if you litigated
regardless,
or
you think you're right or that instance was the carpet, right?
Right.
The tenant think the downstairs think the plywood make a noise, right? And the carpet, the tenant feel the same way. The carpet is old, and if you place when you take out the carpet, you fasten the plywood, and also you put a little bit better pad, and then the carpet on that. So in that way, they'll be better. But the owner point is the carpet is still good enough, right? I don't need to do it. But a carpet is a long time because but it's still it's really debatable situation. So that's why they had a dispute with the association, had a dispute with the tenant. So that time she wanted legal advice. I said, well, she asked me. I said, you better get legal advice,
right?
And so the lawyer was very honest, which is great. So you can either pay me and then fix it, or you can just fix it. So she fixed it.
Yeah,
So
which she did. That's good. That's
Yeah.
always the best option. So at least she's happy, the tenant's happy, and you avoid
Yeah,
going,
at least
you
she
avoid
went through that. She
Yeah.
understood, because at least someone listened to her point of view, but gave her the advice. In this case, even though you think you don't need it.
Yeah,
but,
and it's unfortunate because we
yeah.
have had clients that have told us they've gone to court because there was a dispute about, in one particular case, there was a dispute because the tenant had damaged a section of the kitchen floor, and the landlord ended up, after the tenant moved out, replacing the entire kitchen floor. And the landlord's position was, well, I couldn't find the matching tile, so I had to replace the whole floor. Therefore, I want you, the tenant, who damaged it, to pay for the entire floor. The tenant disputed that. Then there were a few other items that they didn't agree on. So the long story short is the landlord went to court, was tied up for a week, and ended up, I think, losing on every case because the judge said if there is any damage that they did, it has to be prorated to the amount. So in other words, if the floor is 100 square feet, if the tenant damaged, let's say 10%, 10 square feet, you're only entitled to be made whole on what the section that was damaged. In this particular fact pattern, again, every fact pattern is different, but in this case, the judge said you can't make yourself better on the bank of the tenant.
So, it's not better because, say, for example, right, kitchen floor. If this is the laminate floor, right? I mean, the town group click together.
Right.
You cannot just
that's every.
Plus, if that batch sold, you can't match it.
Right. Well, that's that's
unless you want to have a two-color kitchen.
You know what?
floor.
The court said tough. And
that's what I'm saying.
So,
it depends on the judge.
Facts, exactly right.
Yeah.
All right, we're going to take a quick break. We'll be right back after these messages. Okay, welcome back to our show. So the last thing I want to say about security deposits is that make sure they're returned in a timely manner after the tenant vacates. It must be returned within 30 days. And if there is any damages deducted, there must be an itemized list with what the deductions are for, and preferably with receipts. And it's probably a good idea if you and the landlord and tenant both agree and have both parties sign off on it to say, hey, per our discussion, I'm deducting, X, Y, and Z, and the amounts of, $100 for this, for the broken window, or $200 for whatever, the damaged stovetop or whatever. So it must be actually itemized if you're going to deduct. You can't just deduct the, whatever monetary amount and not have an itemization on it. So let's talk about another important topic with New Jersey leases, and that's also covered under the New Jersey Truth in Renting. Situations that give rise when a tenant can legally get out of the lease. Mm-hmm. That's something a lot of people may not be aware of, that even though you sign a lease, you're contractually obligated, New Jersey protects tenants in certain situations. Number one if a tenant is the victim of domestic abuse or sexual abuse, and there's a documented pattern, and they have either police reports or something from a qualified professional documenting that the living conditions where they're at are not sustainable due to the domestic abuse. So that's one valid reason the tenant can end the lease without penalty. Another important case, which makes sense, is military members. If the tenant is in the military and they're subject to serve with active deployment and they have to move out, under the federal law, the Service Members Civil Relief Act, they provide protection to the tenant and allow the tenant to get out of the lease in that particular situation as well.
They protect the country, they protect us. So the least thing the landlord can do is release them, right? Yeah, that's the least that we can do, right?
Exactly, that's the least. They're doing something far braver and protecting our country. So that's understandable. It makes sense, right?
Yeah.
Another situation we're going to talk about is if truly the property becomes unlivable. And unlivable, it has to rise to a serious standard where there's like serious things like the heat isn't working and it's not been repaired for a long time. There's maybe roof leaks and they haven't been addressed. There's a serious mold issue. The serious electrical problems are really bad. Safety hazards. They have to be. It has to rise to a certain level. And if the landlord fails to address them after getting proper notice, then the tenant may have cause to pack up and leave and stop the rent. But again, you have to consult with an attorney. You'd have to have your fact. Everything
before you do anything, don't consult the attorney.
Yeah, because the landlord has to have an opportunity to address that after receiving the proper notice, which is a legal way.
The landlord and the tenant both should seek legal advice.
In this case, though, if it does happen, it becomes something that's known as constructive eviction, meaning that the landlord has allowed the livable conditions to deteriorate to such a degree that it's no longer livable there. Yeah. And so the tenant, in essence, is forcibly, forced to move out. That's called constructive eviction. So what I want to do talk about now is one of the
there's something else, because if the person loses job, right?
I think
if they lost a job, they can't afford it. I mean, once again, this is gray area.
That's and I think that in that case, they might still be. Again, it depends on the facts. But if they lose a job and they can't afford it, if they move out, then the landlord has a duty to mitigate the loss. They have to put it on the market as soon as possible and try to find a qualified replacement tenant. And they can't just say, "Oh, you're on the hook for it for the rest of the term, and I'm just going to sit back and make you collect the rent." They have to actively market it, advertise it, do whatever they got to do to find a replacement tenant.
We had once the poor tenant lost the job, but he told us immediately because you want to move back home.
And then some landlords may let them. There's always a case, even if it's not required by law. Sometimes landlords and tenants are both humans.
Is a human.
So
they want to.
So they're going to
want to help each other.
They want to help each other. They might be understanding. They might say, "I don't care what the lease. We'll just rip it up and you can go." Or you might have you might have lost a mother might be sick or a parent might be sick. Yeah. You might have to leave the location where you're leasing in New Brunswick, and you have to go out of state back to New York to care for an elderly person.
That happened too. So, that happened to us too. The landlord released them. Yeah, it's really case by case.
Yeah, so not everything is what the law says. There's also how people do it and how they feel about it. Yeah. But one of the important cases that really served as a landmark case for the implied warranty of habitability dates back to 1970 with the famous case of Marini versus Ireland. That was a case where where basically the tenant experienced plumbing problems, I guess due to a faulty toilet that wasn't working, and they I guess they notified the landlord, and the landlord didn't do anything to fix it. So what the tenant did, they withheld some of the money of the rent. Because they had to pay to fix the toilet. So the landlord got angry and took them to court and basically sued them, saying you didn't pay me the full rent amount. So they sued them to try to get them evicted. Mm-hmm. So this case went all the way up to the New Jersey Supreme Court, and the court basically found that there's a duty. They found for the tenant, stating that that in this case there's the doctrine of implied warranty of habitability. The landlord there's certain basic things that the landlord, if they fail to address it, the tenant can under specific circumstances pay for it themselves and then deduct the rent. But again, it has to be there's very particular circumstances where the tenant would have to give proper notice to the landlord. And it has to be something that rises to the level of urgency, affecting, again, the habitability, the safety.
Yeah.
It can't just be that, the electric outlet in the bedroom isn't working. I can't plug in my alarm clock. It has to be something that's really, really bad. You have to have given the landlord proper notice and a reasonable amount of time to address it. And then if all those things fail, then the tenant can take matters into their own hands and deduct from the rent.
But once again, before you take matter in your own hands, call the lawyer, call the attorney to ask the question.
Yeah. Yes. So the question would be that if the landlord can withhold the rent any time that they're unhappy, the answer would be no. Like for example, if the like you said, if there's a drip on a kitchen faucet. If the toilet is running maybe after you flush it, if it's something that's not, it doesn't affect the habitability. You have to know, it's not, there's nothing, it's not black and white, like what affects it, what doesn't, but you have to, you'll know it when, it has to, it's really dependent on the fact pattern.
Yeah, for example, wintertime, the furnace give it in and you need to get repair immediately for the landlord. So often I get a call, either at night or in the morning, the heat gave up. So we normally help the landlord, call for the emergency HVAC contractor. Yeah, to make sure there's a heat in the unit. Yeah.
Mm-hmm. So what are some of the biggest takeaways you think from the Truth in Renting Guide for landlords and tenants? Number one, again, we want to remind the listeners that if you're in a lease relationship, whether you're a landlord or a tenant, you should read that before you sign the lease. That's a very lengthy document. It sets out the rights and responsibilities of the landlord and the tenant.
It's protect both parties,
right? Yeah. Again, it talks about things like the plain language, just certain points. If there's anything that's agreed to prevent any faded memory, it must be in writing.
Yes.
It should be committed to writing, and the better way to do it is put in the lease. But if there's something else that happens that transpires during the tenancy relationship, it should be put in writing to say what the agreed outcome is between the landlord and tenant. Yep. You put in the lease so you avoid ambiguity.
It's always common sense, right? Anything you do, like agent. Like me, if we discuss about a case with another agent or with even with my own client, right, I always send a quick text, right?
Yeah.
Just say, hey, Ken, I'm nice talking to you again. I just want to confirm, blah, 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 blah. So in the future, if any things rise from that, we can go back what I sent to you, right? You said, yes, okay, thank you, Jane, thanks. Nice talking to you, so good. And then 2 weeks later, you can't say that's not what we agreed on,
right?
Because that's always.
Yeah, people's memories tend to fade as time goes by too. We even had one case of a particular single family home that had the floor. They had beautiful hardwood floor, but in one particular room there was a lot of scuff marks. And then when the last tenant that was in there vacated after being there 2 years, and then the landlord looked at the floor and said, gee, it seems like there's more scuff marks than there was 2 years ago. You think I can get the tenant to pay for refinishing the floor? And I said, absolutely not. The floor, then we went back and we had photos, video, and to show. So that's why, whereas like 20 years ago, you didn't have all these accessory tools. Now you have besides writing it down, committing it to pen and paper or the computer, now you have the photo and the video, which are very, very important to protect
worth
both.
1,000 words.
That's what that's what the saying goes, right?
Yeah.
Right. Yeah. So that's something you can't emphasize that enough. And I think communication is key with during the course of you can probably tell a lot of stories with landlords and tenants.
Yeah.
You have to communicate.
You have to, a lot of time, right? It's not only communicating, Ken. It's the tune of communicating, okay? Sometimes when people write a text, it's totally different from, people can interpret it a different way, right? for example, a long time ago, I was doing a lease with someone. I represent the tenant. Normally, as you know, I represent the landlord. But in that case, I represent tenant. I just wrote to the leasing agent and said, I said, well, normally I represent landlord, but this time, I just want to clarify, blah, blah, blah. 2 seconds, the agent called me screaming on the phone and said, I don't know what's wrong with you, blah, blah, blah. I said, what do you mean what's wrong with me? Why you sent me such a nasty text? I said, what do you mean? So I just read the text again to her. I said, well, I'm sorry you get offended. I don't know why. She said, oh, that's how you read it. Okay, I read it differently, thinking, you're the leasing agent. This time you're not a leasing agent. I said, no, that's what not I said. I said, normally I'm the leasing,
Right.
This time I'm tenant. I want to make sure how you want to handle it. I'm just respectfully asking you, how would you like it to be done the way, right? Because that's you're in driver's seat. But she misunderstood, thinking what I wrote was like really nasty. So, once again, you said communication. It's really how you communicate, right? You could have just write no. And that person could think, oh my God, how rude. You said, well, you can expand a little bit, the message. Sometimes I always like to pick up the phone. I can talk to someone later on, follow up by a text.
Right.
So that would be, nicer and easier.
That's a great tip for landlords and tenants. If you do have a conversation with somebody, then to follow it up in writing with the agreed upon
or email or
now
text.
with the email or with text. Now you have both those avenues available, and you can outline the agreed upon course of action.
If you only had a discussion later on, memory fade.
Right, memory fades. Yep.
Yeah.
So as we conclude this landlord-tenant episode, writing, and writing. Committed to
That's
writing
right.
and video.
Video and a photo.
Video, right. Those are your tools. So everything's in the smartphone. So
a lot of time, right, talk to each other, work with each other. I always tell the landlord, right, having a tenant like have a part-time job. They're your client.
Yeah.
You have to treat them with respect and with a kind heart and work together, right? So this is like, this is a relationship. The day you sign the lease, the day you married them for that period of time.
Yeah. You want to be respectful and work together towards making them happy and, having an enjoyable experience and
they pay the rent. They should enjoy.
Absolutely.
And then the landlord have if you have a good relationship with the tenant, and the house will be taken care, and then everybody will be happy. Win-win. Yes.
All right. We hope you enjoyed the show. We'll see you next week. Have a great weekend.
Thank you.